If you had this independent collateral action, whether under 60D1 or imagine a world without 60B, and you can just bring an independent collateral attack on the judgment, would the defense of laches apply, or would your reasoning there be that, no, there just can never be any limitation, no statute of limitation, no laches defense from the other side if a judgment is void ab initio?
I would say, Justice Barrett, that yes, that there is no laches argument to be made in connection with a void judgment, in the void in the pure sense of the term.
And what do you do with the history? I'm sorry. What do you do with the history that some state courts for decades have applied laches to justice situation? Doesn't that defeat your common law understanding?
I believe, Your Honor, that if we were to, or if the court were to rule that laches cannot apply to a void judgment, then that would.
Yeah, you're asking us to rule that way because
Right.
you say there's a common law. But if there isn't a common law, because there were laches applied by some courts, not all of them, but some, doesn't that defeat your argument?
I would say, Your Honor, that it would not defeat the argument, because if the court were to find that a void judgment cannot be given effect for due process
You're going
reasons.
around in a circle. We can only find that if there really is a common law rule and Rule 60B doesn't override it, because common law rules can be overwritten by 60B.
Correct. And so
if we look at what the advisory committee said when it was creating 60B, was that it wanted to, because the existing rules in common law were quote unquote confusing, one of the purposes of the amendment was to clarify the rule so that the federal rule will be controlling. So what do we do with that?
well, because the enforcement of a void judgment, even to overcome laches, would require a violation of due process.
Could Congress write a rule that says exactly what you want? Even void judgments need to be filed within a reasonable time. Does Congress have the power to do that?
I was going to say, Your Honor, I don't think Congress has that power because the Constitution, because of the Due Process Clause. And so if the court were to find in Coney Island—
But you gave up constitutional arguments in your brief.
I'm sorry, Your Honor?
You gave up constitutional arguments in your brief.
I think we didn't give up constitutional arguments, we gave up an argument that Rule 60C1 itself is unconstitutional. But the Due Process Clause still exists, obviously, and so we would say that the Due Process Clause would require an overriding of a laches argument.
Thank you, counsel.
What falls within the category of void judgments in your mind? Like what are the range of things that are in the category?
It would have to be, and the court has spoken on this several times, it would have to be a judgment that was entered in the absence of subject matter jurisdiction, personal jurisdiction, or some other defect that would cause a similar effect.
Some other defect, do you have any others that you know, offhand that fall within that same category?
Potentially bribery of a judicial official, or some other defect that goes to the very heart of the court's power to hear a dispute.